Welcome to my channel CA Gayatri's Academy, and today we are going to deal with the procedure of appointment of whole-time director, managing director, manager under section 196 of the Companies Act 2013. Let's begin with the topic. The procedure for appointment of whole-time director, managing director, manager under section 196 of the Companies Act involves the following steps. So we will do the steps one by one. Eligibility criteria, section 196(3). What does it say? A person shall not be appointed as an MD, that is managing director, or the whole-time director, or the manager if he or she is below 21 years of age or above 70 years, unless approved by a special resolution. If he is above 70 years, he can be made a director or whole-time director or manager by passing approval by a special resolution. Okay, and he and she is an discharged insolvent or has been adjudicated as an insolvent, right? Or he or she has been at any time been convicted of an offense involving moral turpitude, okay, by any court or tribunal, or he or she has been disqualified under section 164 of the Act. Okay, what are the disqualifications of a person to act as a director? I have already discussed in one of my videos of section 164, has been explained clearly in that video. Okay, go and watch it there. So a person shall not be made appointed as a MD or whole-time director or manager if he is below 21 years or above 70 years. if he is 70, अगर वो 70 साल का है तो एक स्पेशल रेजोल्यूशन पास करना पड़ेगा जहाँ से अप्रूव करके उसको बनाया जा सकता है. ओके, नॉट बिलो 21 years. Undischarged insolvent or adjudicated as an insolvent or convicted of an offense or disqualified. So these were the criteria under section 196(3) to make a person eligible for being appointed, okay, in this posts. Second is board approval. Second step is the approval of the board is required under section 196(4). Step 1, obtain the director identification number for the proposed appointee if not already available. So the director identification number didn't have of the proposed appointee has to be taken if it already is not available. So it has to be obtained first. Second, conduct a board meeting. A board meeting has to be conducted and have a board resolution approving the appointment of the director. Said director has to be passed. So a board meeting has to be conducted, and in the board meeting a board resolution have to be approving the appointment of the person has to be passed. Then third step, issue a notice of general meeting to seek shareholder approval if required. So all the cases does not require the approval of the shareholders. There are specific cases will do just sometimes. Next, so it issue a notice of general meeting. A notice of general meeting has to be issued to seek shareholder approval. So these were the second step, that is a board approval under section 196 would have to be taken for the appointment. Then shareholder approval. When does the shareholder approval comes? There are two cases. Let's see what are they. First, as per section 196(4) and rule 3 of the company's appointment and remuneration of managerial personnel rules 2014, what does it say? Shareholder approval is required when there are two cases. One, if the appointment is for a term exceeding 5 years, अगर 5 साल से ज़्यादा exceed कर रहा है appointment of the whole-time director, manager or managing director, then the approval of the board is required. Or if the proposed appointee is above 70 years of age, so special resolution is required and the shareholder approval is required for him being appointed as the director, managing director, manager or the whole-time director. Then fourth point, filing with the registrar of companies, ROC. The company must file form DIR 12 within 30 days of the appointment. So in the Companies Act, the company has to file DIR 12 within the appointment of within 30 days of the appointment of the director, said director. If remuneration is payable, okay, file form MGT 7 annual return and form AOC 4 financial statements as applicable. Okay, if remuneration is also involved with these things, and then file form number MGT 7 annual return for the annual return of the company and the director, and the form AOC for financial statements as applicable for the case has to be filed with the registrar of companies. And form MR1 is required if the appointment is in accordance with Schedule 5 of the Companies Act. So we will just sometimes go back. We will do after some time. We will do the Schedule 5. What does it say is about the appointment. So form number MR1 is required if the appointment is in accordance with Schedule 5 of the Companies Act. So these are the filing of the register of companies. These are the files which have to be filed. First, form number DIR 12 within 30 days by the company. Second, if remuneration is payable, then form MGT 7 annual return, form AOC 4 financial statements as applicable, and form MR1 if required for under section accordance with the Schedule 5 of the Companies Act. Okay. Terms of appointment and remuneration, section 197 and Schedule 5 deals with this particular issue part. The appointment shall be subject to the conditions of Schedule 5 and which prescribes limits on remuneration. How much remuneration will be given, that is stated in the Schedule 5. And in case remuneration exceeds limits, central government approval is required unless the company meets conditions in Schedule 5. And if the remuneration is exceeds, then central government approval is required unless company meets the conditions in Schedule 5. Right. So these were the terms of appointment and remuneration, which is mainly taken under section 197 and Schedule 5. Right. So Schedule 5 we will do that clearly. Disclosure compliance. Company must disclose appointment in board's report. Section 134, it must put it in the board's report. Second, annual return. Section 92 should include the appointment of the said director, the managing director, whole-time director, or the manager. Okay, so annual return and board's report, it should be disclosed, and maintain necessary records as per secretarial standards. SS1 and SS2 has to be maintained. These are the mandatory to be maintained as per secretarial standards. Okay, so these are the disclosure and compliance. Disclosure, it has to be disclosed in the board's report as well as the annual return. And what are the maintenance required records? That is SS1 and SS2 as per secretarial standards. Right. So latest amendments which have come up in this appointment case, let's see. Companies Amendment Act 2020 removed the requirement of central government approval for appointment if a company is not meeting profit criteria under Schedule 5. Okay, so 2020 Companies Amendment Act has removed the requirement of the central government for giving requirement of the central government approval was required if it increases the or exceeds the profit motive. So it has been removed by the Amendment Act, Companies Amendment Act 2020, right? And Companies Amendment Act 2017 made amendments related to reappointment before 1 year of tenure expiry instead of earlier restriction of 5 years. Earlier, before 5 years, no one could be reappointed, but now Companies Amendment Act 2017 has made amendments related to reappointment of the before 1 year of tenure expiry. That is, in the 4 years, the expiry. On the 4th year it can be done instead of earlier restriction of 5 years. Before 5 years it could have not been done earlier, but the amendment has done reappointment can be done before the expiry of 1 year, right, of tenure expiry. Right. Let's see the conclusions. What they are saying: by following the above procedures, a company can legally appoint a managing director, whole-time director or manager under section 196 of the Companies Act 2013, and proper filings, approvals and compliance with Schedule 5 are essential to avoid penalties. Okay, so we can say proper filings to ROC have to be done, approvals of the shareholders board have to be taken, compliance requirements have to be secretarial standards as per secretarial standards, as well as the disclosure in the annual return as well as in the board's report has to be done, and Schedule 5 matters have to be dealt with, which are very essential in order to avoid the penalties. Now we will do in just a short way what are there in the Schedule 5. Okay, let's see what does Schedule 5 says of the Companies Act in India. Lays down the conditions for the appointment of the managing director, whole-time director or manager without the central government's approval, particularly when a company has inadequate or no profits. Okay, so Schedule 5 states of the Companies Act states the conditions are laid down when the company has no profit or the profit is less. In that case, particularly when the company has inadequate profit or no profits, how the Schedule 5 companies have to be appointed, how the directors have to be appointed. Okay, so it provides eligibility criteria, limits on remuneration and procedural requirements. Okay, here is a summary of the Schedule 5 says appointment of MD, the managing director, whole-time director or the manager. Let's see what are the conditions to be fulfilled for appointment without central government approval. Central government approval is not required even if the profit requirement is not matched, that is inadequate profit or no profits. Okay, persons must not be convicted under any act related to the company law, securities, etc., and sentenced to imprisonment for a period exceeding 6 months. So if the imprisonment is for 6 months, below 6 months, then he can be appointed. But if it is exceeding 6 months, then in that case he or she cannot be appointed. And convicted under any act, it has been related to companies law, securities, etc., and sentenced to imprisonment has to be less than 6 months to be appointed. But if it exceeds 6 months, then he or she cannot be appointed. Then detained under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. Okay, if he has been detained by any law prevailing under the Conservation of Foreign Exchange and Prevention of Smuggling Activities, etc., okay, Act. Then undischarged insolvent or adjudicated as an insolvent or suspended payment to creditors or made a composition with them. Suspend payment to creditors, when creditors he has not paid the creditors from whom they have taken the money for the supplies, and made a composition with them, and has already undergone any composition with the creditors of the company, not completed 25 years or over 70 years of age unless approved by special resolution. Okay, and he is not of 25 years and 70 years of age unless approved by special resolution. So these are the person must not be, he is not 25 years of age or he is above 70 years of age. If he is 70 years, then a special resolution need to be passed. Okay, nationality must be a resident of India. And for being a resident of India, what he has to satisfy, he has to be in India for 12 months. Okay, let's see what they're saying. A person who has been staying in India continuously for at least 12 months prior to appointment is considered as a resident. So prior to appointment, he has to stay in India for 12 months, and non-residents can be appointed with central government approval. If non-residents need to be appointed, then the central government approval is a must. Otherwise, for the case of a resident of India, where resident of India is a person who stays in India for the preceding 12 months, he has been staying in India continuously, okay, for a period at least 12 months for prior to appointment is considered as a resident. So these are the conditions for fulfillment of appointment without central government approval, right? Remuneration when company has no profits, inadequate profits or no profits. Okay, if limits on remuneration, it provides limits on remuneration payable as a percentage of capital or fixed amount which can be paid without central government approval. Okay, central government approval is not required even if the remuneration payable or the percentage of capital or a fixed amount when company has no profit, inadequate profit, company complies with certain conditions like shareholder approval, filing required returns have been filed by the company, and not defaulting on dues. When they are making the call monies have been paid, everything, the company complies with certain conditions like the shareholders approval, then the filing required returns, and not defaulting on dues. Okay, limits are based on the effective capital of the company, net worth plus reserves plus borrowings, and limits are based on the effective capital of the company's effective capital. What does the effective capital says? It says the net worth of the company along with its reserves plus borrowings, how much money they have borrowed from the market. Okay, so net worth plus reserves plus borrowings minus investments, whatever investments it has to be deducted from the amount, and that will be considered as the effective capital. So on the percentage of profit is taken out. Okay, so remuneration when company has no or inadequate profits, first it will fix the amount which can be paid without central government approval. Okay, when the shareholders approval is there, when filing of returns have been done perfectly and no defaults are there, and limits are based on the effective capital of the company. Okay, so the percentage profit will be based on the effective capital of the company, right? Example, as per current limits, effective capital negative or less than 5 crores, 60 lakhs max yearly remuneration, 60 lakhs, 5 crores to 100 crores, 84 lakhs, 100 crores to 250 crores, 120 lakhs, and if the amount exceeds 250 crores and above, then 120 lakhs plus 0.1% of excess 0.01% of excess of 120 lakhs, right? If it is 1 lakhs, then on the 1 lakh rupees, the 0.01% will be levied. Okay, so these limits can be doubled if the special resolution is passed by the shareholders. So these are the current limits: 0 profit to 5 crores profit, 60 lakhs, 5 crores to 100 crores, 84 lakhs, 100 crores to 250 crores, 120 lakhs. And if the amount exceeds 250 crores, then in that case what will happen? 120 lakhs plus 0.01% of the excess. These limits can be doubled, okay, if special resolution is passed by the shareholders. Shareholders pass the special resolution, then it can be doubled also. The board of the appointment, the terms of appointment and remuneration must be approved by the board and then by the shareholders by a resolution. Okay, a resolution has to be passed regarding the remuneration and appointment. Okay, the first it has to be approved by the board and then by the shareholders via resolution. Okay, remuneration should be disclosed in the board's report. In the board's report, the remuneration, amount of remuneration has to be disclosed. Okay, so thanks for watching.